If you own property in Missouri jointly with someone, or you're thinking about owning property jointly with someone, you might think you're protected. And in some cases, you're right. But there are serious risks that can be involved with joint tenancy property. We're going to talk about those today. Hi, my name is Dan Schnurbusch. I'm an estate and probate attorney in the St. Charles area, and we serve clients all across the state of Missouri, and we help them with issues related to probate when somebody passes away. So today we're talking about joint ownership of property, stuff you need to know about it, how does it work when somebody dies, and what are some of the pitfalls associated with it. So here's the basics. There are two main ways to own property with somebody else in the state of Missouri. Three if you count tenancy by the entirety, and we'll get into that in a minute. So let's say you have two names on the deed. In Missouri, the default form of co-ownership is called tenancy in common, and the default is actually equal co-ownership. So if there's more than one person on the deed and it doesn't specify otherwise, the default ownership is equal. Now with a tenancy in common, if one of the owners dies, the property does not automatically transfer to the other co-owner. Instead, their interest in the property falls to their probate estate and then passes according to the intestate laws or under their will. The other surviving owner, if they're still alive, they still own their interest. It could be a half interest or whatever their percentage is on the deed. The other form of co-ownership is called joint tenancy with right of survivorship, and that's what we're focusing on here today. The main difference with joint tenancy is that when one person dies, the right of the deceased person doesn't pass to their estate, it doesn't go under their will, instead it automatically transfers to the other co-owners, okay? And the third kind of co-ownership is called tenancy by the entirety. It's exactly the same as joint tenancy, except only it works between spouses. And the other added advantage of tenancy by the entirety is that if one of the spouses has a debt or a creditor against just them, the property is protected from any kind of creditor recovery for a tenancy by the entirety property. So what do you have to do? If somebody dies, what do you actually have to do when you hold a property as joint tenancy by right of survivorship? Well, the first thing you have to do is you have to check the deed and make sure the magic language is there, okay? And when you're trying to create a joint tenancy or you're trying to determine if a piece of property is held as joint tenants, you need to look for the magic language. So it should say something like, grantees are John Smith and Jane Doe as joint tenants with right of survivorship. We need that magic language. If we don't have the magic language, it's probably a tenancy in common, okay? Assuming you have that language in the deed by which they took original ownership. So it's usually going to be in a warranty deed or a quitclaim deed, some kind of trustee's deed. Most of the time it's going to be a warranty deed or a quitclaim deed, all right? When one of them dies, what do you have to do to clear up the title? In most cases, you don't need to do anything. Although the proper thing to do is to file an affidavit of death to show that the deceased person is gone and that they died on so-and-so date, and therefore the surviving owners now own the full property. Most of the time, you don't need to do this, because if you go to sell the property or refinance the property, in most cases, the title company is going to take care of preparing that affidavit of death for you. You don't need to get an attorney involved in most situations. But what are the advantages of joint tenancy? The main advantage of joint tenancy is that, again, when one person dies, it automatically slides to the other owners. Now, a lot of people use this as kind of a makeshift estate planning technique to try and make sure that the property passes to their kids or children when they happen to pass away. And if everything goes according to plan, it can do that. But there are problems with handling the property that way. For example, one of the main problems when you have a joint owner on property is that you cut your basis adjustment down. So a lot of people don't realize that when you die holding property and your heirs inherit it, they receive the property with what's called a fair market tax basis. So think about it this way. Anytime you buy property, that sets your tax basis. Let's say you bought a property for $150,000, all right? And let's say then it appreciates to $250,000 because you've held it for 30 years. Now, when you die, and if you were to turn around and sell that property, you wouldn't be taxed on the full $250,000 that you sold it for. Instead, you'd only be taxed on the difference between $250,000 and what you bought it for at $150,000. So you'd only be taxed on that $100,000 in gain. That's your capital gain. And whether that's long-term or short-term, depends on how long you've held the property. In that hypothetical, it would have been long-term capital gain, taxed at much lower rates, okay? But what happens when you die holding property is that your heirs receive a stepped-up fair market value basis. So what that means is if you die holding the $200,000 property with $100,000 of built-in capital gain, your heirs will inherit the property with a $250,000 tax basis. So if they turn around and try to sell the property, they will have zero capital gain because they'll subtract $250,000 of income from $250,000 tax basis, leaving zero in capital gain. It's a very powerful tax mitigation strategy when deciding how you're planning your estate. And the reason that this can cause a problem in the joint tenancy context is that let's suppose there are two owners who equally contributed to the property in buying the property, and you put your child on there. The property might only receive a 1/2 basis step up when 1/2 of the ownership passes away. That is not ideal, right? And proving otherwise can be complicated because there can be situations where you can prove to the IRS that, yeah, I paid all the money for it and so on, but then you're going to have to go through that process in order to validly claim a full basis step up for the surviving owner, okay? So that's problem number one with joint tenancy. Problem number two is creditor exposure. If you've got multiple property owners on a piece of property, you could envision a situation where one of them gets sued, has a judgment against them, and the judgment creditor is able to put a lien against that property that you might be a proportional owner in. So could that result in the property being sold at foreclosure in order to satisfy a judgment creditor? Potentially. So you need to be very careful about who you put on there and whether you're exposing the property to liability of other people by doing that. So in most cases, the better alternative, if what you're trying to do is to leave property and make sure that it slides over to your heirs easily and cleanly at death, generally what you want to be doing is put a beneficiary deed on it or put it in a trust. And that's how we would handle it here in the state of Missouri. There are other situations where the answer might be different, but in general, one of those two things is generally what you're going to want to look at doing. Other things you need to do after somebody who is a joint owner passes away, want to make sure you talk to the property tax people at the tax assessor's office and make sure that the ownership is reflected on the tax record changes. You're going to want to call the insurance company and make sure that the insurance is updated to reflect the change in ownership and to ensure that you're not overpaying for insurance when one of the owners is gone. You're also going to want to make sure that any utilities are switched over into the names of just the surviving owners. And if you have a situation where the last owner has passed away on a piece of joint tenancy property, then you're going to have to go back to square one. Does it have a beneficiary deed on it? Is it in a trust? If not, then that property may now be probate property and need to pass to the surviving owner's heirs at law. So it can be very helpful to make sure that you're reviewing this language and really understand it. A lot of times you'll see different companies or real estate people that don't fully understand the implications of the title structure that they're putting on property, or they'll make assumptions about what you want. It's important to be very vocal and clear about how you're taking title and understanding the implications of how you're taking title when you buy a property or file a deed related to a property and changing any of that information about a piece of property, okay? So that's it for this time, guys. Remember, joint tenancy has to be deliberately created. It does pass outside of probate, but it can have tax and asset protection implications. For estate planning purposes, we want to look at beneficiary deeds and trusts as a safer way of transferring that property. But if you do find yourself in a situation where a joint owner has passed, you probably don't need an attorney. In most cases, you can just get it done through the title company. But if you ever do need an attorney, don't hesitate to call. My name is Dan Schnurbusch. I hope you enjoyed this video. We'll see you next time.